Good afternoon. May I request everyone to please look at their respective screens for our house rules. Kindly turn off your microphones and camera during the speakers' presentations. During the presentation of speakers, take some notes and park your questions. There will be an open forum after each presentation. Should you have any questions during the question and answer portion of the program, please feel free to use the Zoom chat box and type in those questions. For those who are watching the stream via Facebook, you can type in those questions in the comment section and I will read them for you. The program is about to start in 3 minutes, so I just sit tight and relax. Okay, so thank you very much. Good afternoon to our participants and guests. Welcome to our event entitled Technology Transfer Day 2, International Protection and MSE Adoption of University Intellectual Properties. I am Neil, and I will be your host for the day. This event would not be possible without the support of the following institutions: UPLB Techno Transfer and Business Development Office, the Southeast Asian Regional Center for Graduate Study and Research in Agriculture, or SEARCA, and the Philippine Council for Agriculture, Aquatic, and Natural Resources Research and Development, or PICARD. Earlier this morning, we had the Net Pitch Season 2, which highlighted a pitching presentation of the following technologies: the micro-encapsulated fruit bioactive powder from Bignay, cacao pod husk dietary fiber, dust up duck TM, convective hot air dried salted duck egg powder, seaweed dryer, and aquasave. And I hope everyone had a great time this morning. And we are also looking forward to hearing from interested industries so that we can discuss the presented aforementioned technologies. So, to introduce our first speaker for this afternoon, he is the director of Levy Rise Investments Proprietary Limited, based in Australia. He established the University of Western Australia's Office of Industry and Innovation and acted as the director for 13 years. Our speaker has an international reputation in technology transfer, having served as the chair of various tech transfer organizations, including Knowledge Commercialization Australasia Incorporated and the International Committee of International Technology Transfer Network in China. He has been working with the World Intellectual Property Organization, or WIPO, in the Asia Pacific region, providing technology transfer training and remote mentoring to universities and research institutes. So, without further ado, ladies and gentlemen, let us all listen and give a warm welcome to Dr. Andrew Sharakowski.
Hello, can you hear me?
Loud and clear, sir.
Very good, very good. So perhaps we can start by me thanking you for the invitation. And it's great to talk to you. And as you may know, I do a little bit of mentoring to University Philippines de Los Banos on some other projects as part of my work with the WIPO, with the World Intellectual Property Organization. So as you can see, I'm going to try to give you an overview of university technology transfer, but I think it's important to connect this with industry engagement. I already heard you say at the start about connecting with industry. These are local industries in the Philippines, and this is an important part. You cannot easily dissociate technology transfer from industry engagement. Anyway, let's just say that I'm going to try to give you an international flavor. It's mainly going to be a US and Australian flavor, maybe a little bit of from England, but that is going to be tempered a little bit with some more practical things at the end of my talk. So if you look at the next slide, I think that a very good example is the COVID pandemic, which we are all facing. And okay, I think that was my introduction. So really, we're looking at universities' charter of community engagement as being the main area for research commercialization and industry engagement. Even though most technology transfer officers report eventually to the vice president of research, the actual part of the university that's engaging with the community is where the main thrust of tech transfer is. And so that's very important because research impact, whether it be locally or internationally, benefits society and also benefits the economic development of the country. So moving on here. Next slide. Right. So I think one good example of how well universities have interacted with industry has been the development of the vaccines. We're all facing this COVID pandemic at the moment. And, these vaccines have been brought to the market in record time. Whether it's the UK, Oxford and AstraZeneca, the University of Queensland, Australia with CSL. All of these efforts have shown how important industry to to university collaborations are. You may not know, but Moderna is actually a technology based on an MIT inventors technology, which has been developed through Boston Children's Hospital. And even therapies, which not vaccines, but which help with treating COVID, like remdesivir and so forth, these are all from public-private partnerships. So this shows how important, working with industry. This obviously is in the pharmaceutical and the vaccine area, but in many other areas, whether you're in agriculture or other areas, very important for the university to work closely with industry. So the next slide, I always like to explain that people use invention, innovation, they mix these words around, but they really mean two different things. Invention is clearly to invent something new or novel. It can be a thing or it can be a service or whatever. But innovation is the whole process of getting that invention into a commercially viable product or a service or a business. So you're going to have in the university, you're going to have a lot of inventions, and a lot of these inventions will fail because there are various reasons for that. There may be insufficient resources or money to take it through the innovation cycle. But in many cases, and we'll come back to this at the end, the invention is not market focused. So it's basically an invention, it's something really exciting, something neat, but its fit in the market is not that good. So we'll come back to that. Anyway, let's move on to the next slide. This is just another way of looking at how the university technology transfers. What's the challenge? On the left side is the university, on the right side is a commercial partner or the commercialization area. So at the university side, there's lots of ideas, and there's some of these go to prototype, and then many, many less go to product development, and very few end up as sales. The opposite is true. Researchers often think that there's been thousands of dollars spent on their research, so the value is high. Well, actually, the value is very low from a market point of view, right? Not from the point of view of the inventor or the academic. So that value is actually low in the university, but should it go to the marketplace, it can become high in sales. So this is just a way of showing that there's a challenge. The challenge is to get these ideas converted to products and to sales. So moving on, we have the next slide. This is from my previous university, University of Western Australia. And those of you working in tech transfer will recognize this process pretty well. On the left says your research, obviously the research of the academics. And then that leads to an invention disclosure. Someone says, I think I have something that is inventive, that is new, or maybe we should patent this. And then the tech transfer office will need to assess that and check the commercial potential and determine if it should be protected by patenting or trademark or whatever. That's the protection strategy. Now, this is just a way of showing that in my previous university, there might have been 40 to 50 invention disclosures submitted in a year. Maybe 15 or 20 of those had some commercial potential, but only about 5 or 10 of those did we protect by patents or some IP. The next step is very important, and if the University Philippines Los Banos doesn't have a proof of concept fund, then I suggest you look at this, because it's very important sometimes to put some money to develop the research from the idea into the potential next stage, into the prototype. And if you have these notes here in front of you, you can just Google UWA Pathfinder Fund and you will find how that works and the rules and so forth. And, then your partnering happens with a number of companies, and then maybe some licensing happens. Maybe there's some consultancy for the university, or there may be some spin-out company, and the revenues. It's funny, I updated the slide only a year ago. This number was 1 to 2 million in total. it's only grown to 10 to 15 million is because we have now a few drugs in the marketplace. Anyway, I think those in tech transfer will understand this process. And it doesn't always follow this linear step of A, B, C goes down like this. Sometimes sometimes an investor will come in right at the end here and then say that he would like to invest some money into the research in the university. So it's shown here in a linear way, but it doesn't always follow that way. Anyway, moving on to the next slide. Yeah, and I think this is just a way of saying, if you look at the middle part of the slide, it requires investment to get latent IP over to real IP. People quite often say, well, we have some patent applications and that's really good. Well, yes, that's good. But until you have granted patents, the IP is what I call latent. It's potential, but it's not real. And some of you who are working on agriculture will appreciate that if you have granted plant breeder rights like PBRs, then that's a form of real IP. So this is just a slide to show how intellectual property can be developed, and this takes time. So it doesn't necessarily mean that this can be done very quickly either. And of course, it will require time and money. Next slide. This slide is really trying to show a little bit about that research commercialization actually interacts with industry engagement. Because if you look at my three things there, they are interconnecting circles. You have industry research contracts, you have licensing to industry, and then you have maybe the formation of spin-out companies from the university. But each of these can lead to related things in the other circle. If we just take, for example, industry research contracts, let's say industry is supporting a particular project at the university and particular IP conditions are in there. Well, if something interesting comes from this research, then this can lead to a license to that industry partner, or it can also lead to a spin-out company. So this slide is only showing that these three areas, although they are different, licensing, spin-out companies, industry research contract, they are interrelated. And I'll leave you to think about that, but I have had a lot of cases where these things have moved from one box to another. Sorry, from one circle to another. Next slide. This again is a slide. This is a decade of data, so 10 years of data. But what it shows in the blue is where the university had some patents or patent applications, and where industry was interested in these patent applications and decided to fund the research to develop the patent application into real IP and a license. So you can see on the right side, this is maybe as small as $250,000, and there are a few big ones on the left, like $15 million and so forth. The blue ones indicate where the university holds the intellectual property, and the gray one you see for $10 million, this is where the company had the patents and came to the university and said, oh, well, will you help us because you have good people in this area, but we will continue to own the IP. And that's okay. You can have all sorts of IP arrangements. What the university got was $10 million worth of research funding over several years. So I think you get the idea that research contracts are very useful with industry and also relate closely to the patent applications held by the university. They can become like a carrot to get the industry partner to come and provide support and money. Next slide. This is really just saying that we'll come to this later. There's been a trend, particularly in the US and in Australia and various of the countries that are doing tech transfer for a long time, that they are starting to do more spin-out companies. And I'm not going to read this whole slide, but generally why? Because they see creating more value for the university and for the country. So the next slide will show some US data. And if you look at this, don't worry about this data being a little bit old. It's 3 or 4 years old. But you look at the left side, between 1980 and 93, the US universities produced about 820 spin-out companies. And look what happened since then. Each year, more and more and more. So by the time we go to 2015, 16, 17, 18, they are producing more spin-out companies than they did in 1 year. They're producing more spin-out companies than they did in the 14 years between 1980 and 93. So clearly you can see this trend, yeah? And I'm not saying that everyone should swing to startup companies. That's just one form of commercialization. Next slide. These are just some, oops, we jumped. Yeah, this is a way of showing the US tech transfer scene. You can see how much money they spend on research and development, goes to invention, assessment, which they call evaluation, et cetera, So we don't spend much time on this. This is for you to look at, and you can get more information on this. This comes from the Autumn, the Association for University Technology Managers website. So some of you obviously will be familiar with Autumn. Anyway, next slide. Here are just some global success stories. These are all fairly old. The one that I think I want to highlight is down the bottom, Genentech. This was a company that was formed in the late 80s from really good research on recombinant DNA by a professor at University of California, San Francisco, and one at Stanford. And they created a company. And this company almost created the Californian, the West Coast, Californian, San Francisco, Silicon Valley biotech industry. Genentech was sold to Pfizer about 10 years ago for $47 billion. So you can see, and that company not only grew and grew and grew, but it threw out seeds, and lots of other entrepreneurs came from that company. So other companies like Amgen and others. So that's a message a little bit about trying to develop a cluster. If you have a very good technology, then maybe it will be useful to form a spin-out company and try to grow that company locally with other industries supporting it. It's not hard, it's very hard because it depends on economies of scale. And when you look at California, it's a large domestic product. Gross domestic product. It's the size of France in terms of its gross domestic product. But that's the example that I think we can look at. Next slide. We also are lucky in Australia. We have a few large companies. The only thing I would like to highlight here maybe is, for those of you who don't know, that Wi-Fi was invented in Australia. Our CSIRO, or Commonwealth Scientific Industrial Research Organisation. It's an interesting story, and if you have some time, I suggest you Google it. The US patents were granted in 1996. So now they've gone, they've expired. They expired about 4 years ago, but it's a very interesting story. So for those of you using WhatsApp and everything else and Facebook, you can thank CSIRO in Australia for the original inventions around Wi-Fi. Next slide. Yeah, this is just basically talking about how important has become the fact that universities are now contributing to drug discovery. Everyone talks about big pharmaceutical companies, but the last 20 years, the pharmaceutical companies have been passing their research and development out to smaller companies, and of course also universities. Of course, the major contributor here is the US. You can see it's 2/3 of the world universities in terms of producing drugs. Anyway, this is sort of an interesting fact. Let's move on. Next slide. So I'll talk a little bit about trends and myths. I've divided them into two areas. The first myth is people think, oh, the more patents I have, the more money I'll make from tech transfer. Well, that's not true. I mean, look at these 6 top universities around the world. University of California system, 453 granted patents, but only 156 million in research commercialization income. Of course, these are very big numbers, right? So we're not really trying to belittle this. But then look down here at number 22, Northwestern University, only 84 patents, but with 245 million of income. Now, why is that? Well, on the next slide, we will see. We will see that Northwestern University, Lyrica, the drug, which is anti-epileptic drug, if I can say it properly, anti-epileptic drug, was licensed out to Pfizer. So Pfizer's benefited here again. The return to the university is 1.3 billion. It's amazing. I mean, you could create a new university with this sort of funding, right? I mean, that is phenomenal. But that's a one drug. So when you look at the research commercialization revenues from that university, out of the 240 million, 235 million is coming from Lyrica. So what does that mean? That means you've got to be lucky. You've got to have one success. And as you can see here, they are mainly in the biotech area and the drug area. Anyway, you can look at these slides separately. The slides can be shared with anyone who's on the call. No problem with that. So next slide. So I think what we realize, for those who are in university tech transfer, over the last 20 years, we realize that making revenue for the university is not the major focus, because that's not going to happen very often. So what is the major focus? The major focus is making impact in the marketplace, where the inventors and the university can say, our research helped people in the marketplace do this. So, as I said there, only 5 to 10% will make money. Only a small amount will make over $1 million. And these sort of big deals like Northwestern are very rare. And it's also, the fact is going to be, is the industry partner is going to make the majority of the benefit. And that's the way it should be, because the industry partner is taking the risk. It's not the university who is taking the risk, because there are a lot of costs, etc., required. Next slide. So look at this. Stanford University always talked about as being one of the best technology transfer universities in the world. Look at their results since 1970. A lot of invention disclosures. About half of them were issued patents. Another half of that is license agreements. But only 77 generated more than 1 million, and only 3 generated over 100 million. And of those 3, one of them is Google, the invention of the Google search engine, which, by the way, Stanford Technology Transfer Office didn't know what to do with, so it gave it back to the inventors. And the inventors actually commercialized that, but Stanford had a stake in it. So the next slide. I'm just conscious of how much time we have. I think the other focus here is that we are seeing more and more tech transfer officers engaging with industry earlier. And there are certain reasons for doing this. One of them is not saying, well, guess what, guys? We have this nice patent technology here, and what do you think of it? And the other industry people say, well, if you came to us earlier, we would explain to you, you have not got the right idea here. You are sort of doing something interesting, but it's not quite what's required. So the message here is The earlier you can engage with industry, obviously without giving away your IP, but the earlier you can engage with industry, the better it will be. Next slide. I think another myth is that this is more a message for the US where litigation is more common. But, you know, sometimes people think that research institutes and universities will not litigate companies for lost IP or where there are disputed IP. And that's also changed in the last 10 years. I mean, for example, the Wisconsin University sued Apple for patent infringement. They won $234 million. And then they got more money because because Apple didn't stop infringing their patents. So they won over 500 million. Now, these are big numbers, but you can see the message here is not just the size of the dollars and the numbers. It's the fact that if you infringe a patent that belongs to the university, then you have to be accountable. Then you have to understand the university will stand up for its rights. And that's becoming more common in the US. And big companies are not getting away with just saying, oh, well, that's the university. They won't worry about it. We will just keep doing it. So that's a little bit of a message about the change by universities in litigation. Next slide. So now I'm going to come to some more practical things. You know, tech transfer is a profession. It's not to be done by just an administrator. It's not just to be done by an inventor. It requires a combination of skills. So usually the best situation is the inventor provides the technical skills and technological skills, and the tech transfer office staff, they provide the technical understanding. Obviously, they need to understand the technology, but also the market understanding and the business skills. In my experience, it is not good for the inventor to go and start the first round of negotiations with an outside party. That can usually lead to potential problems. So that's the first message. The first message is the technology transfer staff need special skills. And those skills sometimes are through the hiring process, getting the right people. They're also through ongoing training of the technology transfer people while they're in the job at the university. This is another thing I want to stress. The tech transfer office should focus on the market needs and assessment of the technology, not on the IP protection. What I mean by that is IP protection is very important. You don't want to give away your secrets and not have them patented or under a patent application or under some other form of IP protection. But before you get there, before you get to IP protection, the tech transfer office needs to be working with the inventor to say, we see a real opportunity for your technology in the market. And this is why. The market is large. The market is going to be responsive. Some of the competitors in the market are already doing similar things to your technology, but we don't think it's quite ready. We don't want you to patent. We want you to wait a little while we assess this situation a bit longer. Because that brings me on to the third point. A common mistake is to start the patenting process without a good understanding of how or if the invention solves a market need or problem. So what I mean by that is it's very easy to get a patent on some idea, some invention. It might be inventive. You look at the prior art, it doesn't seem to be anything there, and bang, you put in the patent application. And of course, this starts the clock. This starts the clock of trying to develop the invention further, and also it starts the clock of the patent process. And then the inventor is go away for 2 months on a sabbatical. The tech transfer people are doing this or doing some other projects. So you've got to be very, very focused at the assessment part. So the assessment step of the invention disclosure, in other words, where the invention disclosure comes in, that assessment part is critical. And it needs to involve early market research, as well as prior art searching of other patents. So you've got to do all that. There is a 10-point scoring system that we use with WIPO. There are other methods that can be done, but it needs to be done such that both the inventor and the tech transfer people understand where the current technology sits. Is it ready to go to discussions with an industry partner? What else needs to be done to develop it further? When should we patent? Should we patent straight away because it's really exciting and it looks really good for the market? These are the things that have to happen in the assessment phase. So the problem sometimes for the tech transfer people, TTO, they've got to balance the needs of the inventors. Some of the inventors are pushing for a patent filing. Oh, I want to get a patent filing because patents are important, like publications. If I get a patent, it's very important. But that's all very exciting, very interesting. But if the market potential of that invention is not there, then the tech transfer office has to nicely work with the inventor to get them to explain why they will not take out a patent. And this is sometimes a difficult part of the process. Anyway, that's some of the practical, these are not all the practical issues, but there are some of them. So if I go back again, the next slide, to the process, you see we are talking here about these first three boxes: the research, the invention disclosure, and the assessment. Now, if the assessment says, well, we like it, but it's got limited potential, you have to explain clearly to the inventor what do you mean by limited potential. In some cases, it can be, it's no good, we're not interested at all. And that's a different discussion. But in other cases, it can be, it's limited potential because we want you to do these two critical experiments. And if those two critical experiments are positive, come back to us, and I think we will want to patent it and go further. However, if we go upwards here, and it does have commercial potential, now we have to start getting things in line and working out how we're going to protect the IP, which method, patent, trademark, how we're going to do it. By this stage, we should already know who our potential licensees, whether they be in the Philippines or whether they be in Asia or whether they be global. We should already be thinking and making a list of these potential, not competitors, but these potential licensees. And we should be looking at what they have patented in this area and what their interests are. And once we know that, we are in a good position to approach them with our technology. And sometimes you can approach them without lodging the patent, but you must do it under NDA. And many companies will not want to do an NDA at an early stage like this. So then that comes to the decision, yep, we are going to take the patent. And once we take the patent, as I said, the clock starts, and we need to know where we're going with that. That's a point where we can start early negotiations after it's been lodged and we have an application number. We can start early discussion with industry. So the final slide is really just a summary, I hope, of my talk. So why are we doing this? Well, we're not doing it just for the money. It would be nice to have money, but that's really the secondary focus. Well, because the university is part of the university charter. You know, the university needs to get research results into the marketplace. And that shows real research impact. And then there are societal benefits. If you have a good treatment, a drug, or a medical device, then patients and users benefit. and they think that's wonderful. And if they know it comes from the University Philippines Los Banos, then they are very happy with that. And so, and you are happy, and the inventors are happy, and hopefully they make some money as well, and everyone is happy. And the local and national economic development is increased and improved. And it becomes a cycle. So it becomes success breeds success. And the more of these things you can do, the better you can succeed. Whether it's a MSME or a larger company or even an international company, it's important to know how the technology best fits for the marketplace. And of course, in the end, if it's successful, it becomes a prestige boost for the university, not just the vice president, but also the inventors and the inventors department, and of course the tech transfer office that benefited. Anyway, I've gone fairly quickly in parts, but you have my slides, so you can look at them, and I'm happy to take questions either now or sometime later by email if you like. Thank you.
Yep. Okay, so thank you so much, Dr. Sierakowski, for that very educational and inspiring talk on international commercialization, focusing on the university tech transfer and industry engagement in the US and Australia. So, Dr. Randy, please stick around for the question and answer portion of our
Sure.
program. For sure, our participants have a lot of questions for you. Sounds good, sir?
Oh, no problem.
All right then. So for our participants, again, a few reminders for our open forum. Please use the Q&A chat box and type in those questions. For those who are watching the stream via Facebook, type in those questions that you may have in the comment section, and I will read them for you. So let us now start with the Q&A with this question on the board.
Okay. So how do I see that?
All right. So the first question that we have for you is, this is from Miss Jane Reyes. I hope I pronounced that right. How can we encourage faculty researcher to go for patent before publish, more than publish or perish in index journal publication, since the university has immediate reward system for the latter?
Yep. Very good question, and a very, very common question. So there are two parts of this, right? What I encourage the TTO to do is to hold regular, when I say regular, maybe 3 times a year, training sessions for all researchers, whoever wants to come. And in that, there are 2 things that require to be done. You need to explain that conundrum, that hiatus between, not hiatus, that link between publication and patent. If you publish something straight away and it is commercially valuable, that's great, but you destroy the potential to patent it. So that needs to be explained, and they need to understand that first of all. And if that's the particular case, if you believe what they have is commercially valuable, then you have to encourage them to just hold off publishing for a few months or for some time, 6 weeks or whatever is the time you agree, so you can evaluate the technology and say, yes, we want to patent it, and we will patent it, and then you can publish, and that's good. Now, the second part of this question is, how do you encourage researchers, academic people, to become more interested in understanding the patent process? So you have to train them on that, and you have to explain to them, this is how you do a patent search. This is how you check patents. And why is that interesting? Well, they are very, very good at searching research publications. They know how to do that. So then you just transfer it over and say, look, here are some tools, the USPTO, the Philippines Patent Office, Google Patents, whatever. This is how you search for a patent. And there they may find something very interesting. They might find, oh, I'm working in biochemistry or something. Oh, this company that I heard of, they actually got some patents close to my area. And they become interested then in understanding how patents relate to industry and how their work now relates to industry, because the patents the company holds are very similar to the area. So my message is, number one, encourage them to understand the difference between publication and patenting. And secondly, get them involved in doing patent searches so they can understand what patents exist in the marketplace in their area of research.
Okay, there we go. Ms. Jane, I hope Dr. Sherkowski was able to answer your question. So thank you. So on to our next question. Since you mentioned you've been mentoring tech transfer officers in the Philippines, what do you think are the factors that hinders their commercialization or transfer?
Well, I specifically put this slide in, not for University of Philippines Los Banos, but the slide I put in about the assessment step being critical is mainly for, let me go back a step. I have five mentees in Philippines, and I have 5 in Malaysia. I find that the Philippines is operating in what's more a traditional method, which is the tech transfer office is working with the inventors, and they are both attending the mentoring calls, and that's good. But I also think that there is it may not be so much true for your university, but for one of the other universities and one of the other institutes, there is this feeling that it's a little bit administrative. Oh, the researcher's got something good. Oh, let's get a patent application. Let's call up IPO Phil and let's lodge the patent application. And then we forget about what we're doing. Oh, there's a new researcher coming with a new patent application. Oh, that's good. So what I'm saying is, think carefully before you lodge the patent application, because you start the time clock. And once you get the priority date, then you have a year before you need to start thinking about PCT. And PCT, for those who don't know, Patent Cooperation Treaty, is the next stage of the patenting process. And it's more expensive. And university resources in tech transfer quite often are not huge. And so you have to think carefully about your patenting strategy very early on. So my message has been that generally I'm finding that the assessment phase needs more emphasis, not treating it like administration, like, oh, here's an inventor with something really good. Let's take out a patent application and then let's see what happens. The only other comment I would have about Philippines is I have a bit of a problem with this FOR, Fairness Opinion Report, which is, I think the tech transfer officers in the Philippines know how to handle this, but this is a process which generally forces the institutes and the research institutes and universities to go through a non-exclusive license path. And sometimes that is not the best. But that's a much harder thing to change because that's already in the rules and regulations, and that's administered by DOST, the Department of Science and Technology. So that's my comment, but I don't think you guys can change that straight away. It's not possible.
Okay. Oh, okay, Dr. Andy. Thank you so much for answering that question. It's very comprehensive, like I can tell. Okay, so moving forward to our next question. Um, IP enforcement is a challenge to public universities due to lack of legal assistance. How do we ensure that our IPs are not used by other entities? And how do we approach them if found guilty?
Right. Okay. Well, it all depends, because I think you need to. It's a several stage process, right? I mean, if your IP is sitting in a granted patent already, then hopefully that granted patent is already with a licensee or with a spin-out company, or is currently being developed by a industry partner or investor or something. If it's still sitting in the university, then I think that's not very good, because if you've gone all the stage way to a granted patent and it's not doing something, it's like it's a common thing. So it's like inventors will sometimes say to me, I'm from Russia, and I have 6 granted patents in Russia. They're all granted. I said, yep. How many of them are licensed and how many making money? Oh, no, none, but they're very important. They're very good. So we have to break that mindset. We have to break the mindset of just getting patents is not the idea. Getting patents that are making money, or getting patents that are solving a problem, or getting patents that are useful for an industry partner that's working with UPLB is very important. So getting back to the question, generally in the licensing agreement with the industry partner, there will be certain things about the IP, either protection or continuation or infringement. And in some cases, that will fall on the university. And in some cases, that can be written in the license agreement to put more onus on the industry partner. So, for example, they can say there that the industry partner will bear the costs of the patent process going forward. And it will advise the university on the jurisdictions, in other words, the areas, the countries it wishes to patent in the national phase. That's one thing. It can also say there in a different clause, the company will be responsible to identify any infringers of the patent and will report these as soon as detected back to UPLB. And, you know, I'm not using legal language, but this can be put in legal language. And once identified, UPLB and the licensee will determine how to move forward, with legal letters and so on. In other words, it really means you need to get the intellectual property granted and into the marketplace in some form, and don't have the onus just on UPLB to chase people who might be infringing around the world or in the Philippines. I hope I've explained it. I think I've tried to explain it anyway.
Thank you so much for that answer, Dr. Andy. So moving forward to our next question. So based on your technology transfer flow, how can we attract investments for each stage of research and technology transfer?
Okay, well, that's the other point, which is very important. That comes back to generic marketing, number one, and specific marketing, number two. So for each of your technologies that you think are working, have got potential in the marketplace, and you've already got to the stage where you either have IP protection or in some ways or other, then you need to produce a technology brief. This is a non-confidential brief which describes what the technology is, its IP status, what's the problem it solves in the marketplace, and then you have to do some market research. And you say the following 10 companies in the Philippines could be interested in this. And you send it out to them. And part of that technology brief says, we are looking for partners to maybe license the technology, to develop the technology further through a research contract with the university or something like that. So this becomes like a flyer, a marketing brief. It usually is a bit glossy, or it's got like some photograph of the technology or whatever. It identifies the researchers involved and their web addresses, but most importantly, it identifies the commercial contact, the person, the technology transfer office who is doing that. And when it says something like, we are looking for research contract, that's how you start getting people interested to come to talk to you. And then you have a discussion about, well, how much money, what will we do, where will this go, will you be a potential licensee if it's successful, et cetera, et cetera. So that's an important thing. Now, of course, separately to that, you may have in the Philippines innovation grants, government grants, which are specific to bringing in funding to startup companies or people who've licensed technologies from UPLB. I'm not very familiar with the grant programs, but they're generally, these are called non-diluting grants. In other words, they don't dilute the shareholding of the investors or the university, whoever it is in the company, but they will allow the technology to be developed further. I'm sure there is a, I'm trying to think of the group, PCIERDD or something, PC. Anyway, there is a group in the Philippines where they provide grants, innovation grants, and that's one form to access money.
Okay, so thank you so much for answering that question, Sir Andrew. I hope our participants were able to take note of his answer because it's really, it's so educational, like with what we are experiencing right now. So let's now move on to the next question.
Sure.
This came from Mr. Raymond Pignon. So, are we just talking about tech transferring to local companies, or should we also be open to foreign companies instead interested in licensing, buying, or joint venturing with universities for patentable technologies?
Uh, Very good question. It's a very good question because at the moment I'm working with Aina at UPLB on a particular technology which I think has global application. But it gets back to the assessment stage, right? So once you have a technology that you think is very interesting, then as you go through the assessment, you can determine whether, oh, this is interesting, but I think it's just for local application. But I think we should patent it. But I think we should patent it really for a Philippines national patent. And I think these companies in the Philippines would be interested in this. Or we say, wow, this technology is really neat. This technology is sort of some of the technology that's being imported from Germany or from Japan or from China. And this actually is going to compete with those technologies. In which case, you are really raising it more into a global technology. And then you're saying, okay, how do we research and do the market research to understand this technology better? Who are the competitors? And therefore, who are the potential licensees? How much money will it take to get something that will interest them? And we are definitely going to patent this. And we are definitely going to go to the Vice President Research of the university very soon to say to them that we want to go to PCT and we are looking at potential national filings and we are looking at getting a global interested party to license this from us. So the question is a good question because it goes back to my point about assessment. Once you do the assessment, you can say, no, this is interesting. It's not rubbish. It's not something we don't want to do with. It's something that we want to focus on for local application. Or, no, this is really great, and we want to focus globally with this one. So that's the difference. It comes from the assessment phase. And sometimes it actually develops later than that, but we don't need to go into that because I'm just trying to make it a bit simpler here.
Okay, thank you so much for that, Dr. Andrew. Are you still open, sir, for a few more questions?
Sure.
Okay, there we go. So we still have a few more here on the board. So, okay, let's start with this one. Okay, so I think this is rather interesting. So, in your experience, was there an instance where a technology is commercialized, but it was not patented, but rather trade secret? How might the approach to that differ to a patented technology?
Okay. Yeah. Well, yes, I do have a number of examples of this. For example, I would never recommend that. Let's say you have a new software program to do something, yeah, and that is very useful for a particular market segment. I certainly would not recommend patenting the software where you divulge the source code and everything. So that needs to be done by, how should I put it? That needs to be done not so much by market segment. I don't mean that all computer programs should not be patented, What I mean is you need to, again, in the assessment phase, determine where it's going. So let me give you an example. We had a need to produce a online lecture system, which was software and hardware, where the students of the university could look at lectures through Wi-Fi and almost immediately after the lecture was delivered. Okay. Now there were 3 engineers, and this actually came from the arts multimedia section of the university. But we realized that we had a lot of open source software we could use. We could use other and then people were saying, no, we should patent this. We should patent this. And the answer is, no, we should not patent this. We should keep this as a trade secret. The key parts of the technology we can keep as a trade secret. Now, very quickly, that technology was licensed to about 35 universities in Australia and New Zealand. And in 2009, we sold the whole package to a large US company called AnyStream. So the answer is, it's like the sort of cliche is, it's horses for courses. So in some cases, it might be better to keep something as a trade secret. And I think you all know, for example, the story of Coca-Cola. If Coca-Cola in 1905 had patented their formula, then 20 years later, everyone who's making cola, it would all taste like Coca-Cola. But they didn't do that. They kept it as a trade secret. And because they kept it as a trade secret, even today, there are a lot of cola drinks which can't quite taste like Coca-Cola because they have their formula as a trade secret. So it's not an easy answer. It needs to be done by considering the technology and where it's going or where it's potentially going. Okay?
Okay, so thank you so much, Sir Andrew, for answering that question. So we have here another question from Mr. Michael Hunsai. So, how can one change a researcher's mindset from academic to market-focused research?
That's a good one. It's a perennial one. This problem has not been solved anywhere in the world. So I think you keep working at it. And but to me, the most important thing is that the tech transfer office has to lead this process, right? Because the researchers aren't thinking so much about the market. They're thinking about their narrow sphere of research and so forth. The only way this can be done, I think, is by continual education. I mentioned that that you should try to educate the academics on patent searching and on IP protection in general, and on the difference between publications and patents and so on. And this area forms another part of that education. But I'm afraid you cannot force them to think with a marketing mindset, but you can get them closer to understand that they should be looking for opportunities where their technology has a fit in the marketplace and what that fit might be. If you start getting to think like that, you are getting closer to the solution. But it's not an easy one. The flip side of that is I have seen some very successful researchers who got interested in a particular project which went to the marketplace. And then they went, oh, now I understand it better. Oh, now I have another idea which is related to this. And then I went on and, oh, I have another idea. There's a different idea. And they actually became very involved with the markets and so really, I would imagine that you only get a 10% or 15% of your researchers will get to that stage where they understand the market well. But you can certainly help them with education to get closer to that situation.
Okay, so thank you so much for that, Dr. Andrew. So I think we only have one more question for you, Dr. Andrew, before we end this question and answer portion. So, okay, so this is actually an interesting question. So, how do we encourage the university to focus research on a few areas to optimize resources that may lead to breakthroughs?
Yeah, well, I'm not actually a great fan of focusing the research in particular areas, but I understand where the question is coming from, and I understand why you would want to do this, because you'd want to sort of maximize your resources in some areas. Now, if you know, I don't know, but if you knew the key strengths of UPLB, then I think it's fair that you would try to put more resources in those areas. I think that is only going to come through a sort of closed door discussion between some of the key deans in those research areas, and the vice president of research. And then the vice president of research talks to the tech transfer office and says, we have had some really good discussions here, and we have decided to focus in these 5 areas. And so please, it would be good if the TTO was involved in those discussions, or the director of the TTO was involved in those discussions, because in the end, we need to know where the university management, the hierarchy, is thinking in focusing the resources. So I don't say it's a bad idea, but I don't think, you want to be, because the university has to be fairly broad-based. But I understand the question. The question means, if we were to focus our resources in some areas, how would we do that? And I think that's a discussion between the vice president of research, the key deans of the areas, or whatever you call them, of those areas, together with maybe the director of the TTO, more as an observer, and seeing where those discussions go.
Okay, so thank you so much, Dr. Andy. So actually, that is it for our question and answer. Again, thank you very
Yes.
much for answering the questions of our participants. And we truly appreciate your time and effort. And we also want to say thank you for accommodating our invite amidst your busy schedule.
Yeah, well, thank you very much. I thought the questions were very good, actually. I think they were good range of questions. So thank you for that.
Okay, thank you very much again, Sir Andrew Sharakowski. So also, I would like to say thank you for everyone's participation in the question and answer portion of our program. So to our participants, if you have other questions, please feel free to contact UPLB TTVDO at ctte.uplb@up.edu.ph. So let's now move on to the next part of our program. Okay. So our next speaker for this afternoon's affair is a partner at Cleveland Scott York, which is a European intellectual property firm. He acted as lead IP counsel for many university spin-out companies, especially those in the medical and pharmaceutical field. He's also devoted to help clients achieve their strategic goals by devising and implementing intellectual properties to support them. So, without further ado, let us all welcome Dr. Adrian Bradley.
Thank you very much, and a very good afternoon to you all. It's a very great pleasure to be speaking to you today, and sincere thanks to Glenn Batacados and Joshua for this wonderful opportunity. Apologies for turning up late, but in 2021's equivalent of I got stuck in traffic, I had some problems connecting to the internet. So thank you very much, Andy, for stepping into the breach and covering the earlier slot. And of course, a happy World Intellectual Property Day to you all, and a happy St. George's Day. I had the privilege of listening to Andy's talk, and which I thought was excellent and informative, and I agreed with very much of what was said. And I think in some ways it's appropriate that the IP segment, the nuts and bolts, comes after the technology transfer portion that Andy spoke about. Because a number of times what was mentioned was that intellectual property is appropriate in certain circumstances, depending on what you want to do. So patents are never a means, an object in themselves. They are a means to obtain an object. And from a university commercialization perspective or a technology transfer perspective, what you are seeking to do is derive, in the broadest sense, impact from the academics' research. And patents are, in certain instances, a very helpful way to do that. And I was very interested in the questions that were asked, and I'm looking forward to hearing what you have to say about my talk. So I've got a few slides that we'll whiz through, and what I want to do is give you a flavour of how international patent protection is actually obtained in practice. And this is something that I, in common with most patent attorneys around the globe, do on a regular basis. This is the core of our job, is obtaining patent protection for clients in jurisdictions that are of interest. Could you advance to the next slide, please? Thank you. So at the outset, we should say that IP, or specifically registered IP, is a territorial right. What do we mean by that? So your patent or your trademark is only effective in the country where you have applied for and obtained it. For example, your US patent will only be effective against infringers in the United States, and infringers in Japan can work your invention with impunity. So you are bound by the countries that you have chosen to pursue patent protection. And I think this, something else that Andy alluded to in his talk, is that because we are all prisoners of geography to a certain extent, we are focused on our local markets, local IP protection, and obtaining patents in our home countries. And I was interested in the example that Andy gave of the Russian applicant with 6 Russian patents and no licensee, and I have seen this phenomenon many times. But I think what is important to stress that IP rights are only effective in a single jurisdiction. As I mentioned, they're territorial, but opportunities, meanwhile, are global. And in the 21st century, your customer, and by customer, I mean in the broadest sense, your customer, your licensee, your business partner, where your startup is located, is as likely to be in Philadelphia as in the Philippines. Could you move to the next slide, please? So we've seen from the previous slide that these opportunities are global. We need patent protection in the markets, in the relevant markets where we are going to pursue protection. Patenting is an expensive business, and you really only want to do it when you absolutely have or need to. And we can imagine that for an important invention that we're going to pursue in 10 different jurisdictions worldwide, you can easily anticipate a budget of $250,000. So for most organizations, that's a pretty serious chunk of change. And most universities, and in particular universities in developing countries, that is a very significant amount of money to try and find before revenue is even generated. So what I'm going to talk about for the rest of the talk is how the international patent system exists to help applicants, and in particular to delay costs until such point in time when the business case for a technology is proven and you feel fully justified in making this significant investment in overseas patents. What I thought I'd do to set this in context is give a brief history lesson. So patents, as we know them in their modern form, are really a product of the industrialization that occurred in mostly in Europe in the 19th century. So very significant inventions such as the steam engine were made during that time, and the patent system is by and large a reflection of that process of industrialization. And some countries have a very long standing tradition of granting patents, and for important inventions it became apparent that you needed protection in more than one country. So in significant industrialized countries it was desirable to have a patent. And what was necessary at the beginning of the 19th century was that you applied for these patents simultaneously. That was the only way really to do it. And that obviously involved finding significant amounts of money to instruct attorneys in Germany, in France, in the United States. And what would quite often happen is that the same piece of prior art was discovered in all those jurisdictions, and all that money was wasted. So this became appreciated as a significant issue in the development of the global economy during the middle of the 19th century. Next slide, please. So I've shown you a nice picture of Blackpool Tower here. No, it's not really. It's the Eiffel Tower in Paris, of course, Paris. Why have I shown you a picture of the Eiffel Tower? Because of the Paris Convention, which is a very old international treaty which is still in force, although having undergone numerous revisions over the passage of the more than a century that it has been in existence. So the Paris Convention was signed in 1883 by the initial signatories, and most countries in the world are now party to the Paris Convention. And what the Paris Convention provides is a number of significant rights that are really the underpinning of the modern intellectual property system. So there's three important rights and one unimportant right, in my humble opinion. There's the right of national treatment. So patent granting authorities have to apply the same treatment to foreigners as they do to nationals of their country in the granting of intellectual property rights. There is a priority right, which I will talk about in more detail because that's the one we're really interested in. International exhibitions, that's kind of, yeah, that exists, but it doesn't really have any bearing on what we do in practice. And mutual independence of patents and trademarks. So this basically says that in the country where you're granted a patent, they have exclusive jurisdiction over the validity of that patent, independent of the fate of your patent elsewhere. So really fundamental things to do with the international system for intellectual property, and all of them, as you can see, have an international flavor. So these are concerned with people applying for patent rights outside of their home jurisdiction. Next slide, please. One of the most significant innovations of the Paris Convention in its 1883 format was Article 4, which deals with the right of priority. So the right of priority means, in a nutshell, if you file an initial application for a patent, trademark, or registered design, you have a period of time, 12 months in the case of patents, 6 months in the case of registered designs or trademarks, in which you can file corresponding applications directed to the same invention in other jurisdictions. And the advantage is that they take the effective filing date of the original application. So I think it's easier seen on this diagram. So at the start of the process, you file a single application in your home jurisdiction, in this case, the Philippines. And within 12 months, you can file corresponding applications in Japan, USA, China, and Europe. And those subsequent applications are treated for the purposes of patentability as if they had the filing date of the original application. So I think you can immediately see how this helps applicants. So filing an application in your home jurisdiction is generally not an overly onerous, financially at least, process. So filing an application in the Philippines, the filing fees are relatively low. You have to engage a representative, obviously. But you have this 12-month period when you can check out the technology. As Andy mentioned, is there a market for this technology? And you have that period of time in which you can not only check out whether there is a market for this technology, but you can kick the tires on the patentability of the technology. You can do your own prior art searching, you can have it searched by a professional, you can have it searched by a patent office. And if it looks like Microsoft have got there before you, then you can forget all about it and find something else to do with your money and your time. So this was great. This was a massive stride forwards for international patent seekers. However, there's a relatively short period before translations and local attorneys are required. So 12 months seems like a reasonably long amount of time, but trust me, in the world of technology transfer, it goes by in the blink of an eye. Next slide, please. So just to recap on what I was saying about priority, is the main effect of the priority right is that in terms of novelty, the filing date of the first application is considered to be the effective filing date for determining the state of the art of the subsequent applications within 12 months. The filing date of the first application is then defined as the priority date for any subsequent application for the same invention. So, for example, you could have a United States application filed on the 1st of January 2020, which claims the priority of a Philippine patent application filed on the 1st of January 2019. And that US application would be judged according to the state of the art on the 1st of January 2019. Next slide, please. Sorry, could I have the next slide, please? Thank you. So this was wonderful and a big step forward. But what was subsequently appreciated in the 20th century was that there was a lot of duplication of effort in international patent offices. So under a Paris Convention filing, the subsequent applications were all treated completely independently. And what was frequently the case is that all the patent offices, the German patent office, the Japanese office, the Russian office, would all find the same piece of prior art, and all of the applications would die face down in the mud. And it was heartbreaking for the applicant and a waste of time for the patent offices. So what were the innovation of 1978 was the Patent Cooperation Treaty, which Andy mentioned a couple of times in his talk. And it is a tremendously successful and popular route to initiating international patent protection. The PCT is a patent filing system aimed at simplifying and streamlining the patent procedure for obtaining patent protection in multiple countries for applicants worldwide. It's not a system for the grant of patents. There is no PCT patents or international patents. Okay, so that's very important to note. It's not a means of getting granted patent. It's a means of initiating the patent application process in a lot of countries worldwide. So as of today, there's more than 153 contracting states. Further states are joining all the time. There's more than 100 filing offices and international authorities, and about 180,000 new PCT applications are filed per year worldwide. Could I have the next slide, please? What I've shown here is in graphical form how a PCT application works. Again, we start from a single patent application filed in usually the applicant's home jurisdiction. And after 12 months, we file the PCT application. And according to the Paris Convention, we claim priority to the Philippine application in the usual way. So what happens for the next year and a half is the application is said to be in the international phase. So there is a single application that you file. It is published once after 18 months. And after a further 12 months, you have the option of entering the national and or regional phases for this application. So in the example I've shown here, the applicant files a single application in the Philippines. They file this PCT application, and then 2.5 years after the initial filing date, they enter these nations here: Japan, USA, China, and Europe. Next slide, please. The first advantage of the PCT system, as I mentioned, is that you file a single application. Okay, you don't need to instruct attorneys in countries around the world. You can usually file it in your home jurisdiction. The second advantage is that the International Search Authority will conduct a high quality search on the subject matter of your patent application. This is a great advantage because international search authorities have a certain minimum level of PCT documentation and databases that are available to them that are prescribed by the system. So you can be confident when you have your international search conducted that it will be reliable in helping you decide whether your invention is worth pursuing. It's fair to say that there are some countries offer a choice to applicants. In the UK, we don't have a choice. We have to use the European Patent Office. And the EPO does a very good job of searching international applications. The standards are very high. And other countries also have extremely good quality searches. But there's a range of these, and some of them are more expensive, some of them are less expensive, some of them have a better reputation, some of them have a less stellar reputation. So you pays your money and you takes your choice. Next slide, please. Together with your search, you will receive a written opinion of the International Search Authority. And this is like a mini examination report. The examiner will critique your application on the basis of novelty, inventive step, industrial applicability, all the substantive requirements for patentability, which are universal in PCT signatory states. And this is very helpful, again, to applicants in deciding whether to proceed with this, with protection for this technology. If it turns out that there is a killer piece of prior art, then your investment is relatively modest at this stage, and you can devote resources to other more fecund avenues of industry. Next slide, please. There is also the possibility of engaging with the examiner in what is known as international preliminary examination, and I've summarized it on the slide there, and I don't propose to talk about it too much, but basically it affords you the opportunity to have a positive report issued by the International Preliminary Examination Authority, and that is very helpful when you subsequently seek patent protection in various countries where you might wish to. So summarizing, the PCT has a number of advantages, and it is far and away the most popular mechanism for universities to pursue international patent protection. Next slide, please. Patenting is, of course, a costly endeavor, and it gets progressively more costly the further down the line we go. And what I've shown here is a kind of order of magnitude graph showing the costs at each point. When you file your patent application, you incur a certain amount of official fees, drafting fees, etc. And a PCT, the official fees are generally much higher than a domestic application. And at 30 months, when you get to the national phase, you are really talking about very serious amounts of money. So by the time you get to that national phase, you've got to have in your mind, well, basically for a university, you've got to have a licensee, or you've got to have something you want to do with the technology and someone who's willing to pay for it. Okay, that's the bottom line. But the other thing I wanted to stress about this graph is, because of the way the priority system works, after the initial filing is made, it's very difficult to change things. So I think the temptation is to draft and file cheap priority applications and worry about the quality later down the line. And that is a completely incorrect approach, in my view. Once you file your priority application, you're on a tram track which only proceeds in one direction. So you're much better off getting a quality product prepared and filed initially, which will not only save you money by proceeding more easily through examination, but ultimately may be determinative of the success or failure of a project, because licensees will have a serious and hard look at your intellectual property. And if they see it is not of sufficient quality, or it's very easy for them to work around, your project will not succeed. Next slide, please. So I'll talk very briefly about national differences. So we've gone through the PCT system, if that's the route we have chosen. And now we are dealing with various national and regional offices. And these places differ sometimes very significantly in substantive and formal procedure for the grant of patents and other rights. To give you, for instance, in Europe, methods of treatment are unpatentable, whereas in the United States, they are protectable. And the case law differs greatly. Although we have these universally applied standards, novelty and non-obviousness, these are applied very differently in, for example, the United States compared to Europe. And it's very important, of course, to have good professional representation. Your patent attorney is your advocate before the patent office, and he or she is responsible for obtaining a commercially meaningful monopoly for you. Next slide, please. Now, this is something, again, that touches on Andy's speech, where to file. So people are, of course, strongly influenced by where they are, and people like, for various reasons, getting domestic patent applications. But where you want to file should be dictated by overwhelmingly where your customers are going to be. So if 90% of the market for your technology is in the United States, you simply don't bother with a domestic application as other than as a means for starting a priority, establishing a priority date. And by customers, of course, I mean also licensees, partners, etc., etc. Enforceability is a factor. So some nations, it is generally recognized that patents are well respected and courts are friendly towards patentees. In the real world, of course, we have to think about the cost of different jurisdictions in terms of protection. Market size obviously is an important factor. And a number of countries around the world offer patent box and similar schemes which give tax breaks to companies who obtain patents and exploit those patents in those jurisdictions. So really a lot of factors to think about where to go. Next slide, please. So what I've shown here is an exercise that we would typically go through for a client. We look at major patenting jurisdictions around the world. We look at the market size, the likely market penetration, the cost of obtaining a patent. Let Excel divide one big number by another big number, come up with a third, more modest number, and in that way you can have a sensible ranking of where to proceed. Okay, so in this case, rebasing everything to the UK, you can see that The Australian market is 95% as valuable, or as value, gives 95% of the value for money of the UK market, whereas the Egyptian obtaining patent protection in Egypt is about a fifth as valuable. So I think doing a systematic exercise like this gives a solid foundation for you to hang your hat on when you're making a determination of where to proceed with patent protection. Next slide, please. So I thought I'd talk a little bit finally about how the practicalities of obtaining an international patent or international patent protection usually work. So, of course, we need an inventor. Everyone needs an inventor. Without the inventor, there is no invention. And we also need a client who may or may not be the same person as the inventor. But the client pays for everything, so he's very important as well. And the way the international patent system generally works is that you have a patent attorney who is closely linked to the inventor and the client. So they're in direct discussion with the inventor. They draft the patent application in collaboration with the inventor. They listen to the client and design the IP strategy depending on the client's wishes. And this individual is referred to as the principal patent attorney, and then they would instruct attorneys in other countries around the globe. Okay, so they have the detailed understanding of the invention and the commercial strategy, and they are in the position then to relay that to attorneys around the world. And the interaction between the principal and the foreign attorneys is more transactional in nature. So objections arise in Europe, the European attorney reports those to the principal. Principal sits down, has a think about how to deal with them, and then sends instructions to the European patent attorney, and they go off and implement those at the European Patent Office. Next slide, please. Okay, I think that's about all I wanted to say. So of course, I'll be very thrilled to take questions, and I'm looking forward to hearing what you have to say.
Okay, so thank you so much, Dr. Bradley, for that very interesting and informative talk on the international IP protection, its origins and applications. So please stick around for the Q&A. For sure, our participants have more than adequate questions for you. So now, ladies and gentlemen, before we proceed with our open forum, please take note of the following reminders. Please use the Zoom Q&A chat box for your questions. For those who are watching the stream through Facebook, type in those questions that you may have in the comment section, and I will read them for you. So, okay, let's now start with a question and answer. So, okay, so the first question on the board for you, Dr. Bradley, is how do we determine which territories should we pursue patent protection for our technologies? What countries should we always consider?
Good question. So it goes back to what Andy was saying. You've done your market research and you've looked at where there is a market for this technology. It could be that there are certain very specific countries which are in a position to take advantage of the technology. For example, if it was something to do with aluminium smelting, there are only 8 or 9 countries around the world which have sufficient hydroelectric power to build an aluminium smelter. So you might want to go for those. However, in general terms, when you do this analysis, 90% of the time, it turns out that the US is the largest single market, followed by Europe, China, and then other other jurisdictions. So yeah, I mean, it's very rare that we would ignore those countries.
Okay, so thank you for answering that question, Doctor. So the next question is, when is the Paris Convention a more appropriate path for international patent protection compared to PCT and vice versa?
It's a good question. Paris Convention is more appropriate when you know at a relatively early stage exactly where you want to go and why. So if you had a technology that had one clear licensee, negotiations with the licensee had gone extremely well, and they said, yeah, we'll take a license under your IP and we're interested in the US, and that's it. Then there's no point going for a PCT application. May as well just go straight into the US and save the time and money. So it's what the PCT system does is buy you extra time, and you do literally buy that time. So you pay the $4,000 or whatever it is extra fees to give you this breathing space. And if you don't need it, don't waste your money.
Okay, there you go. Thank you so much for that answer. So here's a question from Miss Jane Reyes. Does PCT cover community or indigenous intellectual property?
It's a very good question. And I have to admit, I think the answer is no. That's covered by a separate instrument. But I really don't know, because I've never dealt with it. So I'll have to get back to you on that one. I think the answer is no. Happy to be corrected by anyone in the audience.
Okay, there you go. So for our audience, please key in your questions. And I think we can cover a lot of questions for this afternoon for Dr. Bradley. Okay, so next question is, okay, this came from an anonymous one. So may I keep it as a trade secret instead of patenting it to multiple countries?
I'd like to answer this question in two ways. One is a very short way, and the other is quite a long way. So the short way is yes, you may. And I'll give an example of why you might want to. So in the 19th century in England, there was an inventor called Henry Bessemer who invented a process for converting iron into steel. And he was a great believer in the patent system and filed over 200 patents. Now, Henry Bessemer, he needed some money to get his whole thing off the ground, get the whole show off the ground. And what he did was invented a process for making gold paint. And he kept that process a secret, and he worked it in a locked room. He had the machine for doing it built by 4 different factories, and he assembled it in this locked room to which only he had the key. And he didn't patent that. He kept it as a secret. And the reason he did that was that if he had patented it, it would have been appreciated how to build one of these machines, and people would have copied it in non-patented countries where Henry Bessemer didn't have a patent, and been able to work that invention, and it would be very difficult for him to police. Whereas a Bessemer converter that converts pig iron into steel is it's a crucible 100 feet tall with flames coming out the end, so they're more hard to hide.
Okay, so thank you so much for answering that question, Dr. Bradley. So now we have a question from Mr. Ronel Pangan. What if your patented technology in the Philippines, I think it is in the Philippines setup, was used by another country? Is the tech owner have legal rights to sue?
No.
Okay.
No, your patent's territorial. If you if you only have a patent in the Philippines, then you haven't got a leg to stand on in any other country.
Okay, there you go. A very straightforward answer coming from
Yep.
Dr. Bradley. Yep. Okay, so the next question is, since patents are territorial, am I free to use technologies without protection here in the Philippines?
Okay, so the question of obtaining a patent and freedom to operate are two separate things. So because a patent exists in another country and you haven't found an equivalent in the Philippines, that does not mean that you can go and work that technology, because it may be covered by other intellectual property rights, it might be covered by other people's patents. So you need to do a freedom to operate exercise before you embark on doing that. So yes, it is not logically sound to say that.
Okay, so thank you for answering that question. So, okay, on to the next one. Do you have information on the costs of entering the national phase of PCT in various regions such as Asia, USA, and Europe? If the university or individual has no funds, what can he do?
Okay, first question, yes, I do have that information. And you know, rather than if the interested individual wants to send me an email, I can happily send those costs. In the US, it's about $1,000 official fees. In Europe, it's about 3,000. Asian countries, it varies. If the university individual has no funds, what can one do? Yeah, you've got to have the licensee deal with this. So by the time you get to the national phase, if you haven't got a licensee and you haven't got anyone who's willing to pay, then the project has not succeeded, and you're better doing something else.
Okay, so thank you for answering that question. So next, what can we do if the ISR found the technology not inventive? And the follow-up question to this is, what steps can we do to push the PCT? And what would be your advice to this?
Okay, so yeah, don't be alarmed if the international search report says your invention is terrible and horrible. That's their job, and the job of your attorney is to persuade them otherwise. So what you can do is you can go for international preliminary examination, which is a very useful procedure. And the skill of the attorney is persuading the examiner of the merits of the invention. So engage a good attorney who you like and who understands the technology, and the attorney will be able to put on his or her suit of armor and go into battle for you, and you will have a wonderful international preliminary examination report.
Okay, there you go. So again, thank you so much for answering that question. Okay, so I think we have two more on the board. Okay, so would that be okay, Dr. Bradley? Are you still up
Yeah,
for
no,
two
I'm
more
enjoying
questions?
it. Yeah, it's interesting.
Okay, there you go. So let's start with this question. What factors should be considered before filing an international patent?
Excellent question, and I can do you no better than refer you to Andy's talk. Where is there a market for this, and how will a patent help us get market share? So I think before you file a PCT application, you need some strong indicators that the technology is a flyer. I think to file a domestic application, you can kind of do that on a precautionary basis, because it's not that expensive, and you can let most of them fall away if they don't turn out not to be interesting. But as soon as you file that domestic application, you've got to do something with it. and what you do with it should be all focused on that decision. Do we file a PCT with application with this or not? So I think, and people use different metrics for assessing this, but you could think of things like, is there a proven market for this technology? Have we got a licensee in mind? Is there is there ongoing work in this project? Is this a standalone technology, or does it fit together with other things that we're doing? So that's that's the skill of the tech transfer officer, is to evaluate the inventions and decide whether you want to file a PCT application.
Okay, so thank you for answering that question as well. Okay, so yeah, actually we have a few more questions from our participants. Okay, so this is another question from Mr. Ronel Pangan. Is there an unwritten rule that if a patented technology in a specific country must not be copied as a way of courtesy to the inventor?
I wish.
Oh,
No,
okay.
it's kind of the opposite.
Oh, okay, okay.
If a technology proves good, people will copy it, and they will go to any lengths to copy it. No, there's no chivalry in international patent protection.
Okay, there you go. Thank you for that clarification, Dr. Bradley. Okay, so I think someone raised his or her hand from our audience. Okay, I think it was from Claire Ramos. Ma'am, do you have any?
There's got one more question there.
Mm-hmm. Oh yeah, actually, we do have one question here. Okay, so let's start from with this one first. Okay, so if patents are territorial, why are prior arts during examination or prosecution cite patents across all stages or regions?
That's a very nice question. So because the way most countries define novelty, well, I'll explain. There's two systems really, two basic systems. There's local novelty and global novelty, and in places like New Zealand, they used to, and maybe still do, have local novelty. So if something's not known or used in New Zealand, then that's fine. But most countries, almost all major patenting jurisdictions, have global novelty. So if a product is known or used anywhere in the world, that will deprive the invention of novelty. But yes, you're right. There is this dichotomy between patents being territorial right and prior art being global and universal.
Okay, so thank you for answering that question again. So let's now call on Ms. Claire Ramos. I think she has a question for our speaker. Ms. Ramos, are you there? Huh, okay, so I think there's a problem with our a connection or something. So okay, let's just get back on that in a little bit. Okay, because we still have a question here on the board. So I'm just gonna read it. If I did not file for an international patent and the 12 months have passed already, then I saw a country where I would be a hit. What can I do with regards to this one?
There is something you can do, provided that 18 months have not already passed, because at 18 months your application will be published, and that will count as prior art and prevent you getting a patent application anywhere else. But what you can do is, if you're in this grey area between 12 months and 18 months, you can file a non-convention application in the country where you're going to be a hit, and go from there. So there's usually something you can do to put yourself in a better position.
Okay, so thank you so much again for answering that question. And I think, okay, so I think Miss Claire is already prepared to ask out a question for our speaker for this afternoon. Ma'am Claire, are you there? Okay, let's wait for a bit. Miss Claire, are you there? Hmm. Okay, so I think there is a problem connecting to Miss Ramos right here. So if ever you have a question which we won't be able to answer, you can also send us an email via the TTBDO email, which is ctte.uplb@up.edu.ph. Okay, so I think yeah, that sums up our question and answer for this afternoon. Thank you very much, Dr. Bradley, for answering the questions of our participants, and we truly appreciate your effort in answering them.
Not at all. The pleasure and the privilege was all mine.
And for sure, our participants have learned a lot of things when it comes to international IP protection, which could really help them in their future endeavors. So, again, thank you as well for accepting our invite as the guest speaker for this webinar amidst the time difference, Dr. Bradley.
Yeah, I'm sorry about my late arrival earlier on.
No worries, sir. That's not a problem at all because we learned a lot from the talk that you had earlier. So again,
Okay.
thank you very much.
Okay, and yeah, if people want to, if people have further questions, then I'll be delighted to answer them by email.
Okay, there you go. You can also share. You can also share your email address, sir, so that they can send their questions or
Okay.
inquiries. Yep.
Okay, I'll share it in the chat.
Oh, there you go. Okay, so for those who have questions, just send an email to Dr. Bradley, and he'll be more than welcome to answer those questions that you have. There you go. It's okay. I'm gonna mention it as well. It's a.bradley@csy-ip.com. Okay,
That's it.
that's it. Okay, thank you very much again, Dr. Bradley.
Pleasure.
So again, let us now proceed to the next part of the program. Okay. Okay, so our main partner for this webinar series, SEARCA, prepared an AVP which highlights their program called Attain Agriculture 4.0. In line with SEARCA's goal towards accelerating transformation through agricultural innovation, or Attain, let us learn about SEARCA's emerging innovation for growth programs initiatives to attain Agriculture 4.0 through open collaboration, agri-incubation, and technology transfer. Let us all watch this.
Agriculture to hunger and malnutrition eradication. SEARCA has embraced the rhythms of change with new, innovative practices to transform the lives of farmers and the agricultural industry. With its mission to elevate the quality of life of agricultural families through sustainable and resilient livelihoods, SEARCA steers agriculture from the traditional farming production towards an agribusiness perspective in a modern agriculture ecology by accelerating transformation through agricultural innovation to attain Agriculture 4.0. The SEARCA innovates model of open collaboration with academe industry government interconnectivity is a combination of independent but highly integrated component tool designed to attain sustainable development goals through Agriculture 4.0. A modern world transformed by innovative technologies, processes, and dynamics. The SEARCA innovates component tools include Index, as the research and information arm of projects powered by the SEARCA Innovates model of open collaboration. Serves specialists and experts for rural viable emerging solutions that identify and implement innovative but practical solutions to persistent farming challenges. Ideates innovation competitions that focus on engaging the youth, children, students, and brilliant minds in promoting agri-innovation to modernize agriculture and build local rural innovation ecosystems. Blocks building linkages and open collaboration for knowledge systems is an innovative and open shared service hub promoting locally adaptable agri-technologies that can be adopted by small farmers and rural communities. A4 Life Agriculture 4.0 livelihood integration towards farming enterprises for building local and community-based innovation ecosystems and inclusive agribusiness value chains to produce a generation of green startups and agripreneurs. And Space, the Southeast Asia platform to attain collaboration and empowerment for a powerful innovation and open collaboration gateway for agri-incubation and technology transfer information, programs, resources, and networks in the world where SEARCA operates. Powered by SEARCA Innovates model, the Emerging Innovation for Growth, EIG, as the new program in SEARCA's 11th five-year plan steps out from old ways that are no longer farmer benefiting to attain Agriculture 4.0 under three focus areas, namely open collaboration and agri-incubation, knowledge and technology transfer tools, and project development monitoring and evaluation. SEARCA partners to usher farmers out of the belief that farming is limited to production as an agribusiness operating in a modern agriculture ecosystem for better, bigger, smarter impact to farmers and farming families.
Get involved, spread the word. SEARCA innovates. If you're connected with a group that supports agriculture for farming families, we invite you to collaborate with our academe, industry, government partnership for better, bigger, smarter innovations. Together, let's attain Agri 4.0.
Okay, so that was Circus Attain Agriculture 4.0. So the last guest speaker for this afternoon's webinar is the owner and business development manager of Grateful Heart Enterprise, a family business manufacturing arts and crafts, decor, gifts, and handmade packaging. Grateful Heart is continuing the legacy of craftsmanship built through years of producing handmade products handed down by the previous generation. So, without further ado, let us all welcome engineer Jeric Bermudez.
Hello, good afternoon. Can you hear me?
Yes, sir. We can hear you clearly po.
Yeah. First of all, thank you for giving us this opportunity, not only to share about our business, but also how we benefited from being able to get a license from UPLB. The title of my presentation is about licensing UPLB trademarks, or UP, the UP trademarks as a whole. Next slide, please. Yeah, before I start my presentation, I'd like to thank the following, the whole of UPLB TTBDO, Dr. Romel Carlos, Sir Glenn Batigados, the former director of TTBDO, Ms. Jelaisa Mejalbuena, to whom we are coordinating frequently since the start of last year. Also, Sir Joshua for sending out the invitation for today's presentation. And of course, the whole UP community. Thank you very much. Next slide. So what I'll be sharing this afternoon I'd like to present a little bit of timeline about what we do, leading to the use of UP trademarks and how we were able to use it commercially. We are a micro enterprise, very small company in Paete, Laguna, which actually started in sometime in the 1980s. It it's been doing handcrafted items started by the grandparents of my wife. Actually, it's my wife's family business, which she inherited. She started joining the company in about 1998. I myself joined the business only in 2015. We're doing crafts, mostly decor, functional items, handmade packaging. Um, just to clarify, we're not so much into the full carving, in which the small town of Paete is known for, but we do employ carving, but uh, only on a simple manner. The business actually has lots of successes in the past, but there are highs and lows. Business is like that. You will experience successes as well as downtimes as you go through the life of the business. Next slide, please. Yeah. 2017 is an important year for us. It's the time when we actually registered or renamed the company into Grateful Heart Enterprise. And the reason for that is we want to create a new image for the company and explore new things to do and develop new market. Basically, we want to create something new, something different from what we have been doing. It's also the same year that we started doing handmade wooden wall clocks, which will be highlighted a bit in my talk this afternoon. Handmade clocks has been a trend during that time. We were not the original concept creator of this. In our town, uh, some of the manufacturers are also doing this, and we kind of followed on the trend. But we did something different from everyone else in terms of creating more beautiful design and a different look to it. Um, in 2017, it's not uh, like we're following on the success of the previous business. It's actually a difficult time, and we wanted to really create ways of really making the business grow. Uh, it's quite a challenging time for us. Next slide, please. So let me show you some of the handmade wooden wall clocks that um, we started. As you can see, these designs are for institutions like the military, the police, and whatnot. Um, because there has been a demand for uh, such design, especially for police or members of the police organization, in which they wanted something like a badge clock, for example, where they can put their serial numbers and stuff like that. Now, what's interesting is that time we do not have access for an IP license yet. In fact, we do not know how to get one. And when we started inquiring, one organization said that actually they are not accrediting or issuing a license for the use of the design of their logo. Anyway, we continued doing this because of the request from various people. In fact, some organizations are like approaching us to commission us to do it for them. Um, for a certain quantity. We have done a lot of designs for this. I can show you just a few. Next one, please. Okay, 2019. In the past, um, my parents-in-law are actually serving the export market as a subcontractor or just supplying products to exporters and have not really done direct export. It's our dream to be able to do export, and it was in 2019 when we were approached by a UK company to do products for them. Um, you can see in the slide some of the samples that we did. And we were excited at the time, thinking that it could be the breakthrough that we have been waiting for. Because as you do business, you want to be able to establish something for the long term. And we thought that this is it. But unfortunately, as we all know, in the year that followed, 2020, uh, we were hit by the pandemic, and the first order that we got was not sustained. There were no follow-up orders. But we still continued on doing handmade wooden wall clocks, creating new designs, and looking for new customers to serve. Um, as you know, my role is doing business development, trying to find new customers and new market base. Interestingly, there's one story as I was doing cold calling. By the way, I'm sending out a lot of Facebook messages to different organizations, sending out proposals, trying to reach to them, and hopefully we can establish a good connection and gain a foothold. As I approach one unit of the police organization, I got this comment from the admin telling me, because I sent a sample of a product bearing their logo, and the admin told me, "Sir, who gave you the right to use our logo um, for a product like this?" And then I said, actually, one of the reasons why we presented this to you and approached you is for us to be able to somehow get a license for us to produce this product. And then he said, "Sir, please stop from using our logo and selling it commercially." From that time, we realized that it is important to um, get a trademark or a license or a permit to be able to uh, sell a particular product bearing the logo of an institution and openly market it. Next slide, please. Okay, last year, 2020, a good year. Um, well, for me, it's a good year. For us, it's a good year. For some people, they may say it's a bad year because in the Philippines, we started off with a volcano erupting, and then on the third month, everyone was on a lockdown because of the global pandemic. Um, Still a good year for us, although we started off the year without doing anything. We stopped production for 3 months. For a handicraft business, which is not an essential, doing not an essential good or item, we have to close down, stop production, meaning we're not doing anything. There is zero sales, zero, nothing. In fact, most of our workers are struggling at the time. But still, we are optimistic that we may be able to do something. It has been on the back of our mind that uh, we really should secure a license, and we set our sights on um, getting a license from the University of the Philippines as our very first trademark license application. So we approached the UPLB-TT BDO through email, and fortunately for us, they were very responsive. In few days' time, we already got a reply, and then we submitted the requirements. And in roughly less than a month, we were able to get a go-ahead and secure a license. And then we proceeded to product development, created sample, and we were able to market it in a few months in starting the application. Um, the reason why we are thankful to UPLB is because since it's the very first project having a license, the UP community actually is very, I would say, very supportive, very responsive. When we started rolling this, mostly online, we got a very favorable response from the whole UP community. It was so successful that um, even during the first week of selling or first 2 weeks of selling, we got something like around 100 plus orders already. And it kept on going throughout the duration of the license for about 6 months that we were able to sell a few thousand units in just 6 months of selling it online. So the effect on us is really a breakthrough in the sense that um, I was telling you that before that we have been struggling. There are highs and lows in doing business, and we thought last year that this is a breakthrough for us. That it opened up uh, a door of opportunity for us, of possibility. Imagine we're dealing with just one product, one license from a university. How many universities are there in the Philippines? So it opened up a huge market for us. And then we were able to bounce back. And also, we were really blessed to think that we are selling so much at the time when it's impossible or hard to sell a product like this. Like we were thinking, who's gonna buy wall clocks in the time of pandemic? Most people will be thinking of buying essential items like food and clothing and whatever is needed in the house. But wall clocks, it's like an impossible sell. But um, we have been successful in a time when we thought that it's difficult to sell something like this. Um, that's why up to now we are really thankful for the opportunity that has been given to us. Next slide. What we also realize is that um, well we have this in our core value from the beginning, but it solidified the fact that what we have been doing is correct all this while. That business is not just about making money or earning money or to create uh, or generate revenue, but also it's a way to help out other people, especially those people um, who are with you or who are surrounding you. Because of our success selling wall plaques last year, we were able to help um, 9 of our workers, 3 workers augmenting our effort. By the way, we employed last year a couple. The husband is a displaced OFW. He has been working um, for a luxury liner for some years, but because he's talented, we asked him to join us for helping out in the painting of our craft. So we were able to help him out, and also our box suppliers, a handmade box supplier, um, who later testified to us that uh, our orders from them actually got them through during the difficult time of the pandemic, in the sense that the orders they're getting from export are almost zero because nothing is happening from last year. We also was able to help a number of workers from another box supplier. There were countless stories of how people are really thankful that we were able to really got them through from last year. In fact, our own workers, some of them, because they're receiving pay on a piece basis, not on a monthly salary basis. Some of them are actually getting pay which is above the pay grade of minimum wage workers. Also, we were able to help a lot of our network of online sellers. Just to share with you one story of our online seller, in which he was able to support the family and was able to redeem a tricycle which was pawned because of the difficulty of last year. So there are countless stories. I do not have time to share everything to you on how we were able to make this as a social enterprise. We realized that um, the reason why we are doing this even more, or the reason why we are pushing so hard, is because we want to help other people um, um, get through difficult times. Okay, next slide. Next slide, please. I guess this is the last slide. So about TM licensing, what it means to us, um, it really is helpful for a small business like us to be able to have access to a license or a trademark permit, whatever you call it. It is important to us in the sense that the trademark or brand owner has worked hard to be able to protect their intellectual property, register the trademark, so that no one can just use it without their permission. So it's a way for us to respect the trademark or brand ownership, because we know that there are legal implications for not uh, respecting the trademark or brand. And it also works both ways. It's for us as a business, we are also protected in a sense that the concept that we presented cannot or should not be easily copied or replicated because of the permit that was given to us. So that's number one. Number two is for us is reach. Because of the license, we were able to reach a wider customer base, um, simply because there's no legal impediment on the use of the license. Just to share with you, when we started selling the UP logo wall clock, um, there are a lot of questions from prospective buyers, UP alumni. I guess I guess a lot of those from UP are in a way legalistic, but that's good. One customer asked, "Is this a licensed product?" When we said yes, the customer bought at least 5 pieces. Um, Next point is it opened up a lot of other opportunities for us, not only for the UP logo club. A lot of organization, fraternities, and whatnot approach us and have their logo created as well, whether a wall clock or just a simple signage. And we do sold a lot of those products. And lastly, results. Um, it really is important for us that this is not just about, as I mentioned, we are not just doing business or creating money, but success is built by a community helping one another. Um, we we really thought of continuing this mantra that what drive success of any organization is to build a community of people really helping out each other. Just timely, what's reasoning nowadays? You have been seeing about this community pantry going on. This is a classic example of how people helping out each other, not just to cope, but also to help each one build on each other's success. So again, thank you very much, UPLB community. I will end my presentation with that. Again, thank you very much.
Okay. Respect, reach, results. Okay, so thank you very much, Sir Bermudez, for that very inspiring and informative talk on licensing UPLB trademarks and adoption of university IP in your MSME, and for sharing your experiences with the Grateful Heart Enterprise. So, again, a few reminders for our question and answer. Please use the question and answer chat box and type in those questions. For those who are watching the stream via Facebook, type in those questions that you may have in the comment section and I will read them for you. Okay, so let's now start with the question answer portion of the program. Okay, so this is our first question po for Sir Bermudez. What was the most challenging part in acquiring the UP trademark license? Did you encounter any difficulties in preparing documentary requirements?
Um, I guess it was easy for us in a way that we are prepared because documentary requirements are or have been with us for some time. So uh, fairly the legal requirements like business permits, their registration and whatnot, we all have them. So um, it's been fairly easy for us.
Okay, so thank you so much for answering that question, Sir Jeric. Okay, so actually earlier, someone raised his or her hand from our participants. So maybe call on Miss Katrina Aquino. Okay.
Sorry po, I accidentally clicked the raise hand button.
Oh, okay. No worries, ma'am. It's okay po. Pero do you have any questions po for our speaker?
Wala naman po, sir.
Okay. So thank you so much for that, Ms. Aquino. So let's move on to the next question. So this came from Mr. Michael Hunsay. So what would you suggest to UPLB to streamline the process of licensing trademarks? So are there any points for improvement based on your experience?
Um, because of our experience last year, um, and since because the requirements that we submitted are available, I guess I do not have to suggest any streamlining. By the way, just to mention to you, we will now be applying for a renewal with the UP system. We were elevated to the UP system. Um, the reason is that it's a full commercial license, and maybe because all the licenses should now be handled by the UP system. The requirements are more compared to UPLB. Basics are there anyway. Um, I guess no suggestion for streamlining. We are pretty satisfied with the process.
Okay po. So thank you so much po for answering that question. So okay, on to the next one. Are you a part of an MSME organization where your co-MSME knowledgeable in trademark licensing and other intellectual properties that they can use for the business?
We have been actively participating with DTI related events. We consider ourselves as client of DTI for many years. DTI from time to time has been um, sponsoring or facilitating seminars on many things, doing business, financial management. Uh, they are also encouraging people to consider branding and registering particular trademark or symbols of their business or company. So yes, we are part of a community through DTI.
Okay po. So thank you for answering that question. Again, for our participants, just key in, type in those questions that you may have for Mr. Bermudez right here. I think this is actually a really interesting for us to know what really is happening with the Grateful Heart Enterprise. And of course, he was able to share his experience earlier. So yeah, I hope you have lots of questions in your mind right now. So just please share it with us as well. Okay, so moving on to our next question. Would you recommend licensing of universities' trademarks to other MSMEs? And what impact can you share that will encourage other MSMEs?
Yes, given a chance, I would share to them the importance of getting a trademark licensing. Um, it's because it's also a dream of ours to really elevate uh, small industries, like in our case, handicraft, wherein most people in our town are, especially those who are very, very small backyard businesses, in fact, do not even register their business yet. So in a sense, we have to elevate how people do business, to legalize or legitimize their business to be able to reach a greater market or opportunity for them. So that is the first step. And then the second step would be to, if they will be using any um, trademark symbols, logos, whatever, that they should register. Thank
Okay,
you.
so yeah, thank you so much po for answering that question. Okay, so okay, let's wait for a few more questions. Uh, okay, so here we go. Where can we buy your products? What other UP products are you planning to create? And he said, more power to your business.
Yeah, thank you. Our primary mode of selling now is online. We shifted to online since last year. Um, one of the factors is the pandemic. The physical store concept uh, will not work, especially for handicraft, wherein the foot traffic is dependent on tourists coming in our town. And it's also because online is really successful. We have proven that. For the UP logo clock, it's currently not actively marketed because we only got a 6-month initial license, and we are still in the process of renewing it with the UP system. I hope someone from UP system is here so they can expedite the process. Once renewed, we will definitely be promoting it via Facebook through a network of our online sellers. By the way, Grateful Heart has a Facebook page
Okay.
and a website,
Mhm.
but unfortunately, we do not encourage you to buy directly from us because we have a network of online sellers who will be serving you and who will take care of your orders, facilitate delivery, etc. And they will be the ones to respond to your request. But you can still communicate with us. Um, the reason is we want to focus on manufacturing or production, and we can only take bulk orders.
Work orders.
So we will notify you once we get back online for the UP logo clock. And what other designs you're thinking? Um, aside from the university seal, we will design or propose the UP Maroons symbol or logo, which is also registered. And we do also welcome other design suggestions from the UP community. Um, But for now, we are thinking of the University Seal and UP Maruts because these two are the, as far as we remember, the ones registered. Thank you.
Okay po. So thank you so much po, Sir Jeric, for that. Actually, okay. It's actually written in our chat box. So actually, the Facebook page of Grateful Heart is here. So for anyone who's interested, here's their Facebook page. And then Vice Chancellor Lit has a comment. Actually, I think this is just for improvement, Sir Jeric. So she bought the UP clock. It is a bit difficult to look at the hour because of the small, thin size of the number. So can we still improve the design po? So yun. She had this comment for improvement po of the design, sir. Okay.
Do I have to comment on that?
Sir, of course, you may, sir.
Yeah. As for the design, first of all, we are guided by the UP brand guidebook,
Mm-hmm.
in which we have to follow certain design principles. Like, for example,
Mm-hmm.
we have to minimize, or as much as possible, do not have to put any elements in the design which will interfere with the visual element of the seal. We initially used a simple stick-on number uh, to make it appear as a clock. So now, what we will be designing next is to probably put a simple marker, not a number, but a marker, hopefully in brighter, maybe gold color, as an option for would-be buyers to consider whether they're buying with a number or with a marker. So
Mm-hmm.
yes, thank you for the suggestion. We
Mm-hmm.
always welcome them. Any improvements, yes, we welcome them. Thank you so much.
Okay, so yun po. Thank you so much po for that, Sir Jeric. So actually, that sums up our question and answer portion for today. So again, sir, thank you very much for answering the
Thank you.
questions of our participants. We truly appreciate your time and effort, and we also want to say thank you for accommodating our invite as guest speaker for this event.
Thank you so much.
Thank you, po, sir. Okay, so again, thank you for everyone else's participation in the question and answer portion of our program. So to our participants, if you have other questions that we weren't able to answer, please feel free to contact UPLBTTBDO through the contact details shown on your screens. Okay, so there you go. Okay, so understanding the present gaps in the agricultural sector, Go Eden seeks to make groundbreaking contributions to the digitization, which will improve inefficiencies in the agricultural supply chain. Go Eden further hopes that its platform will create an opportunity to study farmer needs and buying behavior, allowing agricultural suppliers and innovators to understand how to best serve their clients and customer segments, and to also encourage agricultural innovation. By bringing agriculture into the digital age, Go Eden hopes to make agriculture modern, high tech, and interesting, thereby encouraging more people to engage in agriculture as a hobby or as a profession. So let us now watch this short video from Go Eden.
Meet Pedro, Edna, and Ivy. This is Pedro, a farmer. He has a vegetable farm and needs to buy inputs every cropping season. He visits an average of 6 stores to complete his input needs for the season and spends time and money traveling to move inputs from the store to his farm. Sometimes he doesn't always find what he needs, leaving him to settle for the next best thing, even if it isn't exactly what is best for him. This is Edna, a supplier. Lately, business has not been good. Fewer people are visiting her store these days. She spends more time and money moving her products, while quarantine measures limit the movement of her sales and delivery teams. She happens to have the products Pedro needs, but because she lives far away, the chances that they'll ever meet are small. This is Ivy, a product developer. She supplies new technologies to improve crop nutrition, but it's hard for her to let people know about her products. Pedro's vegetable farm could do better with Ivy's technologies, but it's unlikely he'll ever know about these innovations or even have the chance to buy and try them out. If only there was a way for Pedro, Edna, and Ivy to find each other. Introducing Go Eden, a 100% Filipino startup, providing a one-stop shop e-commerce platform for agricultural supplies. With a few clicks on the Go Eden website, Farmer Pedro can now find all the inputs he needs, all in one place, online. Edna can now reach more customers than she ever could with just her physical store and current sales team. And Ivy now has a better chance of finding customers for her innovative agricultural technologies. Our dream at Go Eden is to create a virtual place where anyone can buy agricultural inputs without compromising one's needs, where anyone can sell the agricultural inputs that farmers need to keep their farms running and growing, and where anyone can stay up to date on the latest agricultural technologies and even find, buy, and try them out in their own farms. The Go Eden experience is seamless and convenient. With our network of payment partners, you can pay for your Go Eden purchases however you like: cash, card, or mobile wallets. And Go Eden will deliver no matter where you are in the country. With our network of logistics partners, we can make last mile delivery anywhere in the Philippines. Right now, our reach in Luzon is better, but not to worry, because we're expanding our network to eventually reach people in Visayas, in Mindanao, more effectively and efficiently. At Go Eden, we want to connect farmers with the MSME suppliers of agricultural and fishery inputs, or product developers selling innovative technologies that could help farmers. We'd love to work with you and get your products to the communities that need them the most. So what's our commitment to our partners? 1 year waived listing fee, nationwide distribution of products, a guaranteed payment by Go Eden, product spotlight, you could advertise your new product lines on the homepage, sales promotions on the website through photos and videos, improved product packaging and design only by Go Eden creatives. And of course, data analytics to know how well your products perform in the market. Anyone who wants to buy from retail to bulk is welcome at Go Eden. No matter who you are or where you are in the country, we will make agri-technologies and supplies accessible to you. With Go Eden, agricultural procurement has never been easier. Together, let's go connect Filipino farmers, suppliers, and tech developers. Let's go change Philippine agriculture, because agriculture is for everyone. Go Eden, a Filipino startup for Filipinos.
We highly appreciate Go Eden's contribution to the agricultural technology industry. To know more about Go Eden, please visit their website at goedenph.com. They also have a Facebook page, which you can share to your friends or colleagues. Actually, it's flashed on our screens right now. Okay, so don't forget to leave a like on their page and show your support. To officially end our program for this afternoon and share with us her inspiring words of wisdom, let us all give a warm welcome to Dr. Murdelin C. Litt, Vice Chancellor for Research and Extension, for the closing remarks.
Hello. A very, very pleasant good afternoon to all. Wow, this is a very, very fruitful afternoon. And I would like to thank and express my sincerest gratitude to our speakers this afternoon, Dr. Adrian Bradley, Dr. Andrew Sherakovsky, and Mr. Jarek Bermudez for giving a very informative and inspiring talk, for sharing their experiences on international intellectual property and domestic markets, as well as their expertise on trademarks, licensing, technology transfer operations, and on protecting technologies and connecting this to different stakeholders towards positive social impacts. My sincerest thanks also go to all of the participants from various academic institutions, agencies, and industries who joined us today in learning about the potential of intellectual property ideas sought by the current market and the areas and opportunities our researchers can explore in terms of IP development and adaptation or adoption. One of UPLB's mechanisms to contribute to national development is to develop technologies, products, and services that are responsive not only to the needs of its stakeholders, but also to the challenges faced by the various industries in the country. But with the amount of innovation, information, and knowledge in today's society, it is especially important to safeguard our valuable, intangible assets from thieves and impersonators to ensure that it will directly benefit the adapting industries and even the public. Aside from being a form of protection for our brand identity, registering for trademarks, as featured in today's webinar, indeed, it provides competitive advantage and additional income through possibilities for licensing and franchising. And so, activities such as this, Technology Transfer Day, organized by the UPLB Technology Transfer and Business Development Office, serve as strong tools for us to gain better insights on the current market needs and opportunities when it comes to IP protection, licensing, and commercialization. I also believe that these initiatives are crucial entry points for various industries, especially in science and technology, arts and humanities, and social sciences, to collaborate with the primary research and academic institution. This will be a mutually beneficial undertaking because the creativity and innovation we can extend to our partners through our technologies and products can also generate us an additional revenue stream. Hence, I'd like to thank and congratulate Project Leader Glenn Baticados. Sir Glenn, congratulations. Also, Director Romel Carlos, you are now very, very visible, TTBDO UPLB, and the entire staff of the UPLB TTBDO, and of course, most especially the partners, DOSTP Card and SEARCA, for successfully organizing this event. And with that, I am formally closing today's webinar. Together with UPLB TTBDO, I look forward to seeing all of you again when we shall discuss the partnership we will be establishing. Thank you very much and have a great weekend. Goodbye. Thank you.
Okay, so thank you so much for that enlightening message, Dr. Litt. A perfect way to end this afternoon's affair. So that sums up this year's Techno Transfer Day. I hope everyone learned a lot from this webinar, and I hope everyone had a great time as well. I know I did. And we had an amazing set of speakers for this afternoon. Such an amazing day for technology transfer. If ever you have any questions or inquiries after this webinar, feel free to contact us at ctte.uplb@up.edu.ph. Again, this event would not be possible without the support of the following institutions: UPLB TTBDO, SEARCA, and Picard. Thank you very much to our guests and participants who attended this event. This has been your host, Neil, signing off. Stay safe, everyone, and have a great weekend.
Bye.
Bye.